Okay, good afternoon. This is the New York State Commission on Forensic Science. Our meeting of December 11th, 2008. Our meeting is being webcast for those who can't make it into our very crowded room to be present at the Commission meeting. So I'm delighted that we're able to make these accommodations so that people can see the important work that goes on at the Commission. We do have great attendance from our commissioners. We do have a quorum. We have a couple commissioners who are still joining us, but are delayed shortly. So I'd like to begin just by going around the room and asking the commissioners to identify themselves. We also have other people who are presenting today at the table because we wanted to make sure we had seats for them since we have a standing room only crowd. So first I would like the commissioners to identify themselves, and then I'll go around and ask our other speakers. So beginning with Mr. Fitzpatrick.
Thank you, Denise. Bill Fitzpatrick, and I'm the DA in Syracuse, New York.
Peter Neufeld, I'm the co-director of the Innocence Project in New York.
Jim Murphy.
I'm sorry. I didn't hear what you said. Co-director of what?
I'm soft-spoken. Peter Neufeld, I'm the co-director of the Innocence Project in New York.
But it's a good reminder that we also have a court reporter because we do make a transcript of all of our meetings. So I will ask everyone, in addition to looking at the video camera occasionally, to make sure that you pay attention to our court reporter. Okay, Jim?
Jim Murphy, Saratoga County District Attorney.
Harry Corbett, New York State Police Superintendent.
Ann Willie, New York State Department of Health.
Great. Over here, Harvey? Oh, I'm sorry. Marina?
Marina Steich, Office of Medical Examiner, Toxicology Lab, New York City.
Harvey Van Hoven, Director of the Monroe County Public Safety Lab in Rochester.
Peter McQuillan, Office of Court Administration.
Richard Jenny, New York State Department of Health.
Okay, and I understand Barry Scheck and Ivar Goldharp will be joining us shortly. In addition, and I'll go around the table for other people who haven't identified themselves. Gina?
Gina Bianchi, Deputy Commissioner, DCJS.
Mark Bonaquist from DCJS.
Jerry Ziansky, New York State Police Lab.
Kimberly Chabon, Office of Forensic Services.
Michael Cole, Nassau County Police Crime Lab.
Pete Pizzola, Assistant Commissioner, NYPD Police Lab.
Phil Pulaski, NYPD Deputy Commissioner of Operations.
Okay, and we have so many people around in the room, I don't think we'll go and ask each of you to introduce yourselves, but welcome to our meeting, and welcome Ivar. If you want to just introduce yourself for the record.
Sure, Ivar Goldar, late.
Late Ivar.
Not the late.
We also want to congratulate and recognize Joseph Rio, who's with us, and from the Nassau County OME Forensic Toxicology Lab, who I understand is retiring, and we will miss him greatly, but we're glad that you're able to join us.
Thank you.
Today.
It's a pleasure working with everybody.
Thank you. I'm going to begin with reviewing the meeting agenda that has been already sent to all the commissioners and ask for a motion to approve the meeting agenda. Second? Any opposition? All in favor, please say aye.
Aye.
You also we circulated previously a copy of the minutes of our last meeting of October 21st, 2008. To show you that I did carefully read the minutes, I did see a typo on page 3, 17 lines from the bottom that just needs to be corrected by adding the word criteria, the only important criteria that was missed. So I did see one little typo, but aside from that correction, are there any other corrections or additions to the minutes? Could I have a motion then to approve the minutes?
So moved.
Second? Any opposition? All in favor, please say aye.
Aye.
Okay, the minutes are approved. We only have a very short laboratory accreditation schedule today, although we do have a lot on our agenda. So I'm going to turn it over to Catherine Levine and ask her to present on behalf of the Nassau County Police Department lab. Kathy?
You have a letter in your packets. It's a letter from Jim Grinnell from the Nassau County Police Department requesting an extension of the 6-month provisional accreditation and question documents. As you recall, that was voted on at the August 6th meeting. Their accreditation will last until February 6th of 2009. And because we will probably not have another meeting until March or April, they're requesting an extension to give them enough time to come before the next meeting. So I think we just need a 3-month extension. But I will also, Jim Grinnell could not be here, but he has sent 2 representatives from his lab, and Mike Cole is here to address to see if maybe a 3-month extension is enough or he needs further. I just want to add before I turn this over to Mike Cole that we have received the training records in at DCJS for the question document examiner, and the documents, training records document her training since 2005 when she was employed at the New York City Police Department laboratory, and this includes the competency evaluation forms, as well as she also has documents from when she was working even at the Nassau County Police Department as an intern, and she has question document training. So with that, I turn this over. If you have any questions of Mike Cole, I think that's all they're looking for is a 3-month extension. Is that correct?
Yes, that's correct. The inspector said he could make it to us by the end of January. It seems they're very backed up in terms of ISO accreditations. His name is Ed Moylanen.
I'm sorry, I can't hear you down here.
His name is Ed Moylanen, and he assured us he would be there at the end of January. As you said, our provisional accreditation runs out February 6th, so we would like an extension to the next commission meeting.
Okay, so we're going to work on whether we have microphones working here. If somebody could just...
You have to hit the button down at the end, turn it on.
Down.
Now it's on.
Okay, so now keep your Blackberries away from the microphones. Okay, well that seems like a very reasonable request. Is there any discussion, any concerns about this extension to allow the ASCLD lab inspection to be completed in time for our next commission meeting? Could I have a motion?
Make a motion that we accept the extension.
Okay, a second?
Second.
Any opposition? All in favor, please say aye.
Aye.
In terms of our next meeting, I really want to have a meeting in March. I don't want to have to go to April. I think we're doing a good job of making sure we get all our required meetings in during the year. So we have some scheduling issues. Catherine may be talking to you before or after the meeting to try to resolve them and make sure that we get enough commissioners at a particular date. But we will be working toward making sure our next meeting takes place before or in March. So is that it as far as accreditation issues?
Yes.
Okay. I'm sure we'll have many, many more at our next meeting. The next item is a matter that we have been tabling because of our busy agenda, but we now have it down at an early time in our agenda to give Ivar Goldhart an opportunity to talk about this issue. And it's an issue that he raised in conjunction with a matter that was referred to the Inspector General with respect to misconduct at one of our labs, and the issue of the disclosure of the misconduct and the process for doing so. Part of the issue may have been resolved because we do know that the Inspector General does a thorough report and makes that report public, but that's only part of the issue. So I'm going to turn it over to you, Ivar.
Well, thank you very much. And my concern here is that at the end of the day, when all the problems may be worked out with an issue concerning an impropriety or an alleged impropriety with respect to some piece of evidence that has been properly, improperly, or whatever evaluated, at the end of the day, there's no provision to notify, let's call them the decision makers, about what the outproduct of that investigation is. It's not clear what we should do. So consequently, even though, and I used here as an example in my letter, the matters related to the controlled substances with the NYPD, it first comes out in a very innocuous article in the New York Post, deep in the paper, somewhere behind the notices of what the various stars and starlets are doing in Hollywood. And it's just not an adequate airing. Ms. Hammond, as the Inspector General, did write an excellent report which dealt with...
I'm sorry, sir. I'm having a hard time hearing that.
Yeah.
Can you speak up a bit?
Yeah. The Inspector General did write an excellent report, comprehensively reviewing what was her knowledge of the problem and what was going on at the time to resolve it, but there's still no guarantee that would get to the people who are actually affected by perhaps the problems in a particular laboratory. As a counterpoint to that, Bill Fitzpatrick, at our last meeting, was discussing what he does in his county. When an issue comes up, he brings the people in who might have some issue with, relating to a particular problem of an evidentiary analysis, basically gives them the story about what occurs, and they decide whether or not it makes any sense for them to change a position, to make a motion, to whatever. It just doesn't. That process, which Bill Fitzpatrick has in place in his office, seems to be the best way to end the story, so to speak, because only perhaps the judges involved, or the defense counsel involved, or perhaps the prosecutor involved, they're the ones that know what impact, if any, a problem in evidentiary analysis may bear on a particular case. It's not really the job of the Inspector General. It's, and just as an example, in this particular case, the unbelievable effort made by NYPD to get to the root of the problem, to find out the impact of the problem, none of that gets aired necessarily in any detail, except perhaps here, and none of it gets to necessarily the if you will, the end users or the end of the stream. So I raised this issue in a letter to the Inspector General, and I think that it bears some discussion. What happens at the end of the day when there's a Coverdell investigation? Who needs to know? Should we make any effort to expand the obligation? Should we model it after Bill Fitzpatrick's system, which obviously works very well in his county and seems to be ideal? I don't know. I throw this out for discussion because I'm concerned that, A, not enough credit is being given to the entities who are rooting out the problem, and then finally, in addition, there's not a certain consideration given to someone who may feel, rightly or wrongly, victimized by an error that he or she didn't know about. So that's really why I wrote this letter, and I think it's something that I'd like the insight of the committee.
Anyone else want to weigh in on the issue? Bill?
Well, I was just going to say that we have, so many different disciplines represented in this group, and we're all going to be made aware of these reports. And I don't think there's anything preventing us from saying, look, on the basis of this report, I see that the Inspector General has notified all the DAs. I'm going to notify the lawyer on my own. Barry or Ivar or Peter could do that. Or I would say I'm going to notify the prosecutor in this particular area of the state. I think when Ivar wrote the letter, I think we're a little better today than we were when he wrote the letter. So I think what I agree with what he's looking for, that there should be more notification. I'm just not sure that we need to change the procedure that we're using now.
I know Dan Donovan is planning to attend because he notified me that current president of the District Attorneys Association, I think he got delayed, so I don't know. Is Dan here? And I don't want to put him on the spot, but it might be helpful to have him kind of look into the issue or think about the issue and talk to us about, I think a lot of us don't know what the DAs are doing. The Inspector General did as part of the investigation, and I know we as the Commission have always asked the Inspector General to make sure that there is notification to the DAs and that then the DAs have an obligation under law to notify those affected parties in certain circumstances. But I think it might be helpful if we hear more from DAs or the DAs on the commission at another meeting, just what your obligation is and whether you feel the DAs are getting sufficient information to be able to carry out their responsibilities as well under the law.
I would just say, Ivar, in response to your comment, and I agree with Bill's analysis, I don't think anyone would disagree with what you're looking for in the letter. And just from my office's perspective, we have a very similar protocol that Bill has in Onondaga County. And I would suspect that most DAs, although I can't speak for them, would have something similar in place. But it's certainly, Bill and I both serve on the executive committee. If Dan shows up today, it's something that we can undertake to look at in our January meeting.
And perhaps come back to us and talk about the issue. Because I think we don't have jurisdiction over DAs, and we don't have jurisdiction over certain entities other than labs in this commission. That doesn't mean we can't comment, doesn't mean we can't advocate for certain procedures to take place. Barry? Oh, welcome. I'm sorry I didn't see you slip in.
In this connection, I think it might be useful to describe a little bit of the protocol that the Innocence Project has with the Federal Bureau of Investigation.
Can you put that even closer?
Yeah. As some of you might remember, there was a report by the National Research Council on something known as composite bullet lead analysis, where it was concluded that when FBI agents, and it was only the FBI, went into court and testified that, let's say, a foreign bullet had a chemical composition that was similar to that of a box of ammunition, that it came from that box of ammunition, was manufactured on a certain date, or that there were a certain number, a discrete number of bullets that could have been made from a melt of that composition. And the NRC issued this report saying that criticizing that, the FBI decided that they were not going to continue offering this analysis. And then 4 years passed, and then after a story by 60 Minutes and the Washington Post and the project that we worked on, the FBI agreed to go back and look at all of its cases since 1973, and then notify prosecutors. And we developed an agreement with the FBI, whereby we're operating under a protective order. That is the Innocence Project, National Association of Criminal Defense Lawyers, and they have come up with a letter that they send out. They've gone back, they've reviewed all the cases since 1973. Obviously, the guilty plea cases they can't do much about yet, but they get every case where an agent testified and it appears that it resulted in a conviction. They've gotten all the transcripts of the agent examiner's testimony, and then they have a group that rates it, and then they decide what letter to send out. And we've been reviewing that with them, and yes, I was down there on Monday going over their letters with them and we had an exchange. Just last week, a letter was sent out in one of these cases, a man named Ates in Florida. And the way the letter reads is that the FBI sends out a letter saying, and this I think may be of some importance here, what the nature of the problem is with the evidence. But they say, in this case, the agent offered testimony that the bullet came from a box. We don't stand behind that anymore. And that they also sent a copy of the letter to the chief judge in the jurisdiction and indicate that they've working on a project with the Innocence Project and that we may try to get lawyers to assist somebody in that case. So that's known. And then just last week, a man named Ates, A-T-E-S, and I can give you I can show you the motion because it's quite impressive. The district attorney in Florida received this letter, right? The guy was convicted of murder and was a pro se litigant, and he filed this huge motion moving to vacate the conviction, doing a big analysis of it. So we didn't even have to get him a lawyer. The district attorney acted right away. So I think there's some precedent for this, and it may a lot, I think, turns on what the nature of the evidence is. And sometimes in these cases, we don't know anything more than, there was a fingerprint person that had a problem. Maybe you should look into the case. So, but that's a really good precedent. And there's been a lot of cooperation, and I think, for the record, I think the FBI deserves a lot of credit for the way they're handling it. But I think we can do it because that is a massive undertaking. We're talking about 1,700 cases that go back to 1973, and I think we're about halfway through.
So, Barry, if you could get the materials together and provide them to Jim and to Bill, at least they can take a look at those.
Provide copies.
We're really looking at a procedure after. We're looking at a procedure after a finding by the Inspector General of misconduct with respect to a case. I think that's important to keep in mind because a lot of our notifications now have been that there's an investigation, there's a problem, and it involves who knows how many cases, and we have to do a technical review, and there's certainly no finding at that point that anything's wrong. We just need to, undertake the investigation. But when we get to a point where there is a finding of misconduct or some impropriety by the Inspector General, I think it is helpful if we understand how the process will work from that point. So this could be very helpful, and thank you for raising it, Ivar. I appreciate it. Okay, the next item on the agenda is a presentation by Peter Pizzola from NYPD, and he may be joined. I don't know if Phil Pilecki is part of this presentation or not, or anyone else. You're a team. I know you're a team. I know that part. We are having a presentation on really two matters that have been before the Commission on a number of items and to some extent have been closed out under Coverdale, but still had lingering aspects to the investigation. So I will turn it over to the folks from NYPD. And just, you have items in your packet for all of these issues, so I also want to refer you to the materials in your packet. Pete?
Okay. Yes, the first one is the issue of the 43 missing narcotics cases, which I had previously briefed the Commission on last year, and I think that was a fairly extensive discussion. The only change since that past meeting was that the IAB, Internal Affairs Bureau, determined that we were in fact at fault, and that was a member of the laboratory staff that was responsible for the loss of the missing narcotics. It was actually a supervisor on a midnight shift who tried to assist the evidence control folks. We were short-staffed that evening, and he unwittingly moved the bag containing the 43 drug cases next to bags earmarked as garbage. And unfortunately, we believe the drugs were thrown out. And that currently is still under investigation in terms of disciplinary action. The supervisor was the subject of disciplinary action, which is still ongoing.
Okay, we did, I think discuss that our protocol in these kinds of cases where drugs are missing initially is to handle them as a criminal investigation because we don't know if someone's stealing drugs or what the root of the problem is. Once we determine through investigation and the district attorney agrees that they don't believe there's any criminality involved, the issue becomes more a lab issue, and then it's are our protocols in place careful enough to prevent this kind of situation from happening. I know we've discussed in this commission meeting that NYPD instituted certain procedures to make sure that this does not reoccur to the extent possible. Do you want to talk about that?
Yes, just briefly, Commissioner. We instituted a recommendation by IAB to ensure that the midnight shift, where the bulk of our evidence is coming in from each of the boroughs, is adequately manned. so that we have minimum staffing levels which we meet on a daily basis, as well as investing in $350,000 of enhanced security equipment. One of the problems during this investigation was that the camera equipment that monitors where the evidence is being brought in was obsolete, essentially. It was old VCR technology or even old DVR type of equipment. And so we have upgraded the entire system, both with the recording devices, new DVRs, and cameras, to the tune of $350K. And we've taken other precautions as well. For example, one of the key ingredients is that the color of the bags of evidence was the same as the trash bags. So we have required, since we have discovered this incident, that upon entering the lobby of the building, that a large green ugly label be placed on each side of the bag so they can be clearly identified as evidence and distinguished from garbage. So these are the...
Okay, so I noticed the changes are outlined in a letter, just for the record, to Askeladd Labs, dated November 19th, 2008. So is there any additional discussion that the commissioners want to have about this particular matter? Yes.
I'm curious
Dr.
whether
Denny?
you've attempted to challenge the new system by introducing
Challenge what? Did you say?
the new process, by in fact violating some of your new practices to determine whether in fact they are identified as...
I would say we have not attempted to violate the procedure, no.
Violate in a controlled manner, I mean.
Either in a controlled or non-controlled manner. We have not done that yet.
So measures, quality assurance measures to make sure that
Yes.
what the controls you instituted are working.
That's part of the audit process, the quality assurance reviews.
So you will be doing that as part of your
Well,
quality
I don't know
assurance, not
about that, but-
violating, but
I don't know about that specific recommendation. Well, I'll certainly think about it, but...
One of the techniques that we use is that we have supervisors that do what are called unannounced visits. And so the supervisor will arrive. We have captains working periodically on that first platoon at the midnight tour, and they'll go up to the evidence control section and they'll observe to ensure that each bag has got the stickers on it, that the bags are with the messenger. That was one of the problems. The bags had been left at a podium. So by way of observation and visit, this is the way we enforce the rule to ensure that the rule's not being violated.
I'm sorry, who is that that's just...
It's
That's
Phil
Phil
Pulaski.
Okay, thank you.
okay, great. So as you know, we keep a running chart of sort of regulatory matters that we've referred to for further investigation. In this case, it was to the Queens DA. We will be closing this matter out and moving forward. I think you have another item that you wanted to report on as well, Peter?
Yes, Commissioner. This is a firearms analysis section corrective action, which I also have previously fully discussed before the Commission. That it really has been no change since the last Commission meeting when I discussed this. Outside of the addition of a technical leader for our firearms analysis section, we have hired a consultant to act on conducting technical reviews and verifications and audits in conjunction with the quality assurance unit. This is to look at particularly microscopy cases, to give us another set of very experienced eyes to ensure that we are not having any systemic problems within the unit. And then the only other thing I would point out that was additional was the report that was released on November 14th to Askeladd Lab, which I have provided to the Commission.
Okay. Are there any additional discussion matters by the Commission with respect to that matter? Okay, hearing none, that matter will be closed out. And I think one thing that we've seen on the Commission is the extraordinary efforts that the New York City Police Department lab has undertaken in light of several of these cases to invest resources into hiring more staff and taking important quality control measures in addition to what you were already doing to address these issues. And I know all the commissioners recognize that has been an extraordinary effort on the part of the lab.
Thank you.
So, the next item on the agenda concerns the referral that we agreed as a commission, although not unanimously, but by a majority, to refer to the DNA subcommittee. I've included a copy of that letter in your packet. The DNA subcommittee we had hoped was going to meet in December. They could not get a quorum. The folks on the DNA subcommittee are even busier than the people on this commission, which is hard to believe, but it is hard sometimes to get them all in one country at the same time to meet. So we have sent the letter. We're at this point waiting for them to respond. I hope that they will take it up at their next meeting, which is scheduled for
January 23rd.
January 23rd, but I don't know the time frame. But I just wanted to let you know that that letter has gone out, and if there are any other comments, I think we encompassed everything in the letter that was discussed at the commission meeting. Okay, the next matter is on for new business, and Barry has been talking for some time about his concerns about certain types of forensic examination, particularly tool marks and firearm investigations or examinations, and has distributed a number of items, articles to commissioners. And I thought it made sense, rather than to take this up piece by piece or to just have it come up in a meeting and not addressed fully, that we would ask Barry and put him on the schedule and ask him to talk at greater length about the issues and his concerns in the article. And we also, at the same time, will have a presentation today from Greg Cleese, who's a firearms and tool mark examiner at the ATF, who also fortuitously was in New York City to do some training and agreed to stay for an extra day in order to come and talk to us about some of these issues as well from the point of view of a firearms and tool mark examiner in the ATF. So I think it's going to be a very interesting presentation. I hope we've allotted between 20 and 30 minutes to each of the speakers. We may not need that long, and I think we want to reserve some time there for questions and discussion. But at this point, I'd like to turn it over to Barry and ask you to take your...
Can I make a suggestion? Because I didn't realize till I saw the schedule that Mr. Cleese would be here. It might help, actually, if he went first. Because
Okay.
I assume that he will be showing pictures. I don't see where he is.
Sure.
I'm sure he'll be showing pictures and giving us a better sense of exactly how this discipline works. And maybe I won't have much to add.
Okay, that would be fine. And I think logistically, it might make sense for me to move, and you do. Oh, you do? Okay. Okay, great. If everybody, as long as everybody can see you, and make sure you have a microphone in front of you.
While they're setting up, I just want to say a few opening words. I want to thank the Commission for having me here to address the group on this issue. Many of these groups that come together to review areas on our discipline, many times firearms examiners are not represented. We have other people who don't have the direct experience on the bench to have participate in the discussion. So I'm very thankful the invitation to do this. And I always sort of relish these discussions because it just makes our discipline better to get these issues out in the open. And so I really appreciate it. One of the things I'm going to talk about today, when I was invited to this, I received copy of Mr. Scheck's letter about the issues he raised. I just want to mention that besides working in the field of firearms and tool marks for over 31 years with the ATF, and prior to that with the FBI for over 17 years, one of the things that have come up, I was recently voted or appointed as chairman of the Scientific Working Group for Firearms and Tool Marks called SWIG-GUN. As you probably well know, the SWIGs are funded by the FBI through NIJ grant, and we have a consensus of international examiners, and we meet separate from the Association of Firearms and Tool Mark Examiners, AFTI, so it's another group to look at things, get a different view of what we do. One of the things that has been on my mind, because as the article from the Evidence Technology that was passed out, 4 months after the state of Florida Ramirez decision, which was an adverse ruling in a tool mark case where the evidence was excluded, was sort of our wake-up call, and 4 months after that, unfortuitously, I had my first Daubert hearing in Pittsburgh, Pennsylvania on a federal bombing trial. It was a very stressful ordeal because, although I was up to the task, because I've always been involved in science, looking at science behind what we do, even when it wasn't a big issue by many examiners 30 years ago. So I felt the pressure of that, and I learned a lot from that, and thought to myself on what I need more to know and what other examiners don't know. So what we did under the Scientific Working Group back in 2003, we were asked by the president of the Association of Firearms and Tool Marks Examiners to put together some type of learning vehicle to bring people up to speed so examiners can really represent the science behind our discipline and articulate it better, because we were not doing a good job of that on scientific issues. I'm going to just give a snippet here because I only have about 30 minutes. I just threw this together. I would direct you. Okay. The following are excerpts I've just taken out of our Scientific Working Group website, and the address down there is swiggun.org. There's no password required. Anybody can get access to this information. You don't need a password. You don't have to log in and record your name. Anybody, from firearms examiners to forensic scientists to prosecutors to defense attorneys to academic folks, can get access to this and review this. My references in my presentation here are...
Here's a mouse.
It's sort of frozen here. The primary reference on this is under the SWIG, called the SWIG-GUN ARC, the scientific swiggun.org. On the homepage, click Admissibility Resource Kit, or the ARC. It'll bring you right to our kit that literally has all the information on everything you wanted to know on how to prepare for an admissibility hearing, but we're afraid to ask. The second article of interest would be the article by Ron Nichols, my colleague from our Walnut Creek lab in California. He published an article in Journal of Forensic Sciences in May of 2007, defending the science of firearms and tool mark examiners and firearms, and I believe he addressed many issues brought up in articles such as Ms. Schwartz and Mr. Lamagna and Ms. Steele. Another article that I'll refer to is a book by Feynman. He was a academic type. He worked on a Manhattan Project, and he had many articles and press releases and books and articles on the scientific inquiry and the nature of science that I've referred to, and 2 firearms books as background. They're very old, but again, they supply basis of some background information. Basically, quickly, when we look at this, and this is how the SWIG-GUN has identified this, we look at science as a systematic gathering of knowledge, or the observation, identification, description of experimental investigation, and theoretical explanation of phenomena. The scientific method, as you all know, are procedures for the systematic gathering of knowledge. If you look in various science books, natural science books, you'll see that the scientific method varies a lot, but the most common elements are basically these elements, and that's what we formulated on our site to address. Stating a problem or noting a phenomenon, developing a hypothesis, testing it, forming a theory, using the theories to predict events. If we comply with all that, we follow the scientific method. That's why we're trying to articulate why we meet this or satisfy this, and is it considered a science in the discipline. The theory must be testable, must be proven true or false. Theory must be validated through testing of fundamental or what we call hypothetical propositions upon which our discipline is based. The theory of firearms and tool marks is a conclusion of common origin between two compared tool marks can be made when there is sufficient correspondence of distinctive features, or commonly referred to as individual characteristics. That's the theory we have. That's what all of our empirical and validity testing tries to either prove or falsify. The theory of firearms and tool mark identification is based on two fundamental hypothetical propositions. These propositions are, number one, tool marks imparted to objects by different tools will rarely, if ever, display agreement sufficient to lead a qualified examiner to conclude the objects were marked by the same tool. That is, a qualified examiner will rarely, if ever, commit a false positive or misidentification.
A little bit slower because I can't make out what you're saying. That last sentence was a little too...
That is, a qualified examiner will rarely, if ever, commit a false positive error, referred to as a misidentification. The second proposition that forms our theory is most manufacturing processes involve the transfer of rapidly changing or random marks onto workpieces.
Sorry, what?
Random marks onto workpieces such as barrel bores, breech faces, firing pins, screwdriver blades, and the working surfaces of other common tools. This is caused principally by the phenomena of tool wear and chip formation. Microscopic marks on tools may then continue to change from further wear or abuse. That's our second proposition that forms our theory. The science of firearms and tool marks was founded with rudiments consistent to the scientific method. The points 1 through 4 I had listed before in blue under the scientific theory, and we've gone through this and evolved from the turn of the 20th century. We noted phenomenon, observed distinctive features on marked items such as bullets and cartridge cases. The first publication on that appeared in 1900 by Dr. Albert Hall, and progressed through the work of Goddard on firearms and the research work of Luke May on tool marks, or on general tools. This information being captured also on www.firearmsid on the history of firearms and tool marks, more detailed. From these observations of these markings that people wondered about for a while, we developed a hypothesis using the premise of uniqueness, that is, things could be differentiated one from another to form the hypothetical propositions for testing. That's what we did. We noted markings. They look different from bullets or tools from the next. We used that premise, or the principle as defined by Kirk through Tuthill, to form our working hypothesis. We tested the hypothesis, early empirical foundational studies and subsequent validity studies. During the course of approximately 1912, May started working on examining marks made by tools, and around 1916, Goddard and his group developed a comparison microscope, which was adapted from a comparator used in the textile industries to begin studying marks from bullets and from different guns to see if they could differentiate them. Now, during this period, by 1930, after a couple famous trials that Goddard was involved with, most notably in 1929, the St. Valentine's Day Massacre, by the 30s, this was accepted as a science. Well, today, all this preliminary research has been sort of, I won't say poo-poo, but really discounted because there wasn't adequate research and recording of the data. So what has happened in the wake of Daubert since 1993, we've essentially reinvented the wheel. Since approximately 1998 to 2000, numerous more studies have been done and validity studies have been done. I have them listed as we go along to, again, validate the original theory proposed way back at the turn of the century. Forming the theory, after these empirical and validity studies, we are continually validating this, and I have some major studies that have been to list that will support these statements right here. Quick definition, firearms and tool mark, what is it? And its generic term, it's an empirical comparative analysis that can determine if a mark was produced by a particular tool. It can possibly do this. It doesn't always do it. It's empirical, where there's a lot of observation involved, and we're not trying to avoid that because that's been a big issue in many hearings about the empiricism involved and the subjectivity involved. And it's a valid point because there is a degree of human element involved, and as we well know, in many discussions on quality assurance, anytime there's human element involved, we want to have quality assurance measures to try and reduce the possibility of human error. That's what in all the disciplines that we're striving for. Just definitions, class characteristics, general measurable features of a specimen which indicate a restricted group source. They result from design factors and are therefore determined prior to manufacture. That's how Swiggun defines it, and pretty much, I believe, AFTI glossary defines that also. Subclass characteristics, features that may be produced during manufacture that are consistent among some items fabricated by the same tool. These are not determined prior to manufacture and are more restrictive than class. A perfect example of that, in the area on a pair of bolt cutters, the working edge bevel, which is in the red box, if you look at the insert there, a close-up, that was formed by a milling process, what we call a shaping process. Those marks can repeat on new consecutive made bolt cutters. Okay? We are aware of this. We've been aware of subclass characteristics. The first article that appeared as early as 1949 cautioned examiners against that, and numerous articles have been written since. If you go back to the photo on the left, in the box, on the side of the bevel, those are milling marks which could have the potential for subclass carryover, which means they could be carried over from a couple to numerous consecutively made tools that our examiners are aware of. Right below the red box, you'll see there's a blemish, a major blemish or chink put in the working edge of that bolt cutter. That would be produced randomly by use or abuse and is considered an individual characteristic. I use this as an example because many times subclass characteristics are present, but examiners are taught to look for that and be cautious of that. And when I render a conclusion of an individual association or identification, they're going by the individual characteristics. And again, individual characteristics are distinctive marks or features produced by the random imperfections or irregularities of tool surfaces. These characteristics can be used to individually associate a tool to a tool mark. How are they produced? Like I mentioned, these random imperfections or irregularities can be produced by manufacture, wear from use, wear from abuse. Objective examination. This is one that comes up, objective versus subjective. We define as an objective examination as one that can be repeated by different scientists, and if using the same type of equipment and the following same procedures will result in essentially the same conclusion every time. This is our working model that we use when we structure our empirical and validity testing. Subjective examination. The results of a subjective examination are based on an individual's opinion, or what I call a conclusion, which I refer to as a testable opinion. This does not mean that this type of examination is unreliable or unscientific. There is subjectivity in every science and in every test, whether it being a doctor diagnosing a head cold or a chemist determining where to set the baseline on a scientific instrument. What makes identifications possible in firearms and tool marks? By proposition number 2, hypothetical proposition number 2, a sound examination method by employing the precepts of what we call empirical research or study in the comparison of two tool marks. Empirical research or study basically means defines our examination process, which is we compare a questioned tool mark, three-dimensional item tool mark, to an extracted tool mark, three-dimensional item extracted from a tool, whether it be a test fire from a firearms or a test impression from a tool. We compare those 3 dimensions to 3 dimensions, and we do it side by side for comparison. That is where and that's called the empirical research. That examination process technique has been passed down through years. As I mentioned, I believe it was Gravel adapted that to the development of comparison microscope from the comparator used in the textile industry, and also in comparative anatomy, an example like comparative anatomy. You would compare certain items, whether it be bones or whatever, to a known standard or exemplar for comparison. So it's nothing new or unique. Specialized training to develop cognitive skills. An examiner undergoes or should undergo standardized technical training that develops cognitive skills to recognize, differentiate, and understand the patterns of marks and their uniqueness. And this is gained by, there's no way around it, just as an athlete has to continually work and condition themselves, an examiner should undergo sufficient training to develop this type of eye or cognitive abilities, as we refer to it. Significance of the conclusions. Based on propositions 1 and 2, an individual association or identification conclusion can be effective. These individual associations result from the practical certainty of the validated theory and not from absolute certainty. This has been a big point of contention of many articles here in the last 15 years, and some groups that aren't really knowledgeable on the technical details of our discipline many times automatically assume or make the assumption that our conclusions are made on absolute certainty when they're not. What from my research of articles and interviews with examiners through years is what has gotten sort of twisted around is an examiner should have absolute certainty in his confidence in his exam. He has to be 100% sure, or 99.9 repetent 9 if you're using standard deviation. Otherwise, he should render an inconclusive opinion. Definition by Swiggun of absolute certainty or identity: ultimate sureness with no possible change. ID by ultimate sureness with no possible change. Identifications by features whose frequency of reoccurrence is ultimately impossible. We give two different definitions of it. Practical certainty or practical identity: sureness related to practice or action. The second definition we give is identification by features whose frequency is so remote it can be considered virtually impossible. Is it possible? Yes, it could be, but it hasn't been seen in the past in the literature or in an examiner's experience. I'm going to just touch quickly on Daubert because that relates to more of the legal aspect of reliability versus science. We, in Swiggun, under the admissibility resource kit, we've taken it from 4 prongs, we've broken it into 5, because under testability, maintenance of standards and controls has become a very big issue, which I believe it should be. What evidence exists to support the science of firearms and tool mark identification? Numerous empirical and validation studies of consecutively manufactured tools have been published over the past 50 years. We generally use as our experimental model consecutively made tools because that would be our feeling would be that would be the highest probability or possibility where marks could duplicate one tool made right after another in a manufacturing process. So that's generally the experimental set standard we use. Just to give you a sample, and there's more listed under our admissibility kit, consecutive manufacturer studies on gun barrels alone. These are some of the classic ones that have been done. And you can look these up in full citations under our website. Consecutive manufacturings on forged barrels. These were done. Electrochemical rifling barrels. Consecutive manufacturer studies of other firearms components. We've looked at consecutively made breech faces in specific types. Glock breech faces, bolt faces, Ruger breech faces, and extractors. Firearms extractors. Okay. Other manufacturing studies of other tools is chisels, screwdrivers, bolt cutters, drill bits, knives, pliers, and other knife studies. And again, some other tools, hand stamps, chisels, screwdrivers, knives were also done. The last one listed by Clough in 2005, he was an ATF Firearms Academy student, and as his research project, he did a validation study on the Ramirez case where he examined consecutively made knives and took test impressions in cartilage, which was the issue at hand when in the Ramirez case where the perpetrator stabbed the victim in the chest and imparted tool marks into her cartilage in her sternum. He did that and did an extensive study, and that has also been published in the peer-reviewed journal under the AFTI journal. Summary of empirical research. These studies have been found to support proposition number 1, which is tool marks imparted to objects by different tools will ever display agreement sufficient to lead a qualified examiner to conclude the objects were marked by the same tool. That is, a qualified examiner will rarely, if ever, commit a false error if they're properly trained and followed the procedure. I want to just make a quick comment on general acceptance. That's was an issue a couple of years back. It's not as the approval. The general acceptance, as Swiggun defines it, is the approval by a particular authoritative body of a technique or methodology. In addition to the forensic science community, numerous colleges use firearms and tool marks in their course study. Funding of scientific research in the area of firearms and tool mark identification has been granted to researchers outside the firearm and tool mark community. NIJ sponsors that. You have to submit a proposal for a grant, and there has to be sufficient basis that it meets the threshold of scientific study or inquiry to be given this grant. It's been accepted in court testimony for almost 90 years, and although we did a lot of discussion on that pre and post Daubert about the acceptance. Just a sampling of some of the academic programs throughout the world that has firearms and tool marks programs. There's more on the website. Grant programs, National NIJ, AGIS over in Belgium, Canadian Research Council. And again, all these grant programs, you have to submit a proposal on your study. for it to be accepted and grant money to be released. And just some classic, based on the 90 years of court testimony, here are some of the earliest firearms cases that were accepted in court. Quickly comment on peer review and publication. The evaluation of a colleague's research. Selected peer-reviewed journals. These are some of the these are a sampling of journals. There's more under our website that have published, that are peer-reviewed, have formed a direct and indirect peer review process, that have published articles related to research in our discipline. Error rate. We define it as the frequency at which one deviates from a correct standard. Errors can occur from a number of sources and may result in a false positive error or a false negative error. And again, it's important because the first line says the frequency at which one deviates from a correct standard. And we'll probably touch on that later in a close discussion. Various types of error rates have been thrown about. CTS, collaborative testing service numbers, have been used with and played dramatically. They've been crunched around for years and years. CTS, they have the pre-98 where inconclusives were counted as errors, post-98 figures that reduced them down when inconclusives were eliminated. Other numbers, this is all on our website also, along with the pre and post 98 CTS numbers. One thing to point out on this, and I don't care how you crunch it, I'm not a statistician, but when you look at these CTS, they weren't originally designed to measure error rate. They were designed to test the proficiency of individual examiners. And the significant thing is, in these testing, because we're under an accredited laboratory where I'm subjected to at least 2 proficiency tests a year, all the quality assurance measures that we employed at our lab and other labs that were under CTS, the test is conducted exactly with the methodology we're trained and supposed to use, but the quality assurance afterwards is not added to that. Meaning, I'm supposed to work the case, give my results. It's not my identifications, if there are any, are not verified. There's no other technical or administrative review. It's strictly to test the ability and competency of the individual examiner. So logically, if you did these with these numbers, if you did an error rate test with layers of quality assurance or review, the numbers hopefully will go lower because you have external measures, other quality levels of quality assurance to test to double check it. Validity study error rates. These are significant. These are the ones that I think are truly represent our field. Not because I'm biased as an examiner, but in these studies here, these were specifically designed to measure an examiner's, do they get it right or wrong? It's designed to do that, not the level, I'm sorry.
Were these 2 marks firearms or both?
Let's see, Brundage, Hamby and Thorpe, Bunch and Murphy, DeFrance. Let me go down the line. Brundage was a consecutively made barrel study. I'm sorry, Brundage was a consecutive breech face study on Ruger breech faces, 10 consecutively made, and the significance of this study was they conducted a test and they sent these for blind tests through other laboratories around the world and had examiners look at them and give their results. So it wasn't just one lab doing it, like a student doing a research project, having a couple examiners in-house look at it. These were sent around and people actually gave the results. Hamby and Thorpe in 2001 did a 10 consecutively barrel study. And if we go to the bottom, Hamby, Brundage, and Thorpe, this is in peer review right now, and I should be appearing in the AFTI journal either this winter or spring. That's a continuation of their 2001 study. And the error rate down there, they continued. And this last 2008 study will encompass 492 examiners from 19 different countries, and where they've sent the actual test fires from these 10 barrels. Going back to your question, Bunch and Murphy's study, I believe, was on fired bullets and cartridge cases. DeFrance was on, I believe, fired cartridge cases, but I'll have to check on that. Thompson and Wyatt, they did what they call the KIP study, the Knife Identification Project, which is a tool mark study where they acquired 10 consecutively manufactured knives, took test impressions, set up an experiment, and then they sent it to numerous laboratories around the United States, and they tabulated their results. Smith is Eric Smith. He was an Academy grad also. He did a follow-up, and I think it was a validation study of Rocky Stone's first article, or prior research on tool marking, subsequent marks from individual characteristics. He took 20 worn hammer faces, took test impressions, sent them to numerous examiners around the country, and had them identify which marks were made by what hammer. Orange 2005 study was a study done on fracture matching. That, a couple years ago, became an issue that there wasn't sufficient empirical work done on fracture matching. He did a substantial article, and that's in the AFTI journal also. So these are the validity studies that have been done, as you can see, since 1995, that were truly designed to find out, are we getting it right or wrong? And also on this, when they're sent to examiners around the country, there's a requirement they have at least 5 years' experience, minimum 5 years' experience as an examiner. Because there's no getting around it, experience plays a big role in our area, because there is some subjectivity involved. There's no way around it. Okay, maintenance of control and standards. Establishment, we define it as the establishment and maintenance of operational guidelines, protocols for conducting analytical